Without further ado, I'll hand over to Trent. So Trent is from Kruger Law. His name is Trent Wakerley. He's a solicitor. Is that right? That's correct. And,
so far, so
yeah, no, that's right. So the beauty of Trent, not that he's a solicitor that happens to be interested in Advanced Health Directives and getting this information out into the community, but also that his undergrad, so he was a registered nurse. So he has this understanding of relating this to health, and in particular in the community. And he's also had lived experience in his own family about the importance of advanced health directives and caring for a loved one at home in that palliative end of life journey. So I might just ask the people online if you could maybe go on mute. That would be really helpful. Cheers. And we'll be recording this session as well, so we'll put it up on our intranet and eventually on our PHN internet so that we can share it with external stakeholders as well. So over to you. Thank you, Trent.
Thanks, Joe. Thanks everybody for coming. Was it mandatory that you turned up? Or? No. Apologies to Jo. She's already heard this spiel that I did at a presentation over at Stockland there for a volunteer group, and that's where I met Jo, and she thought that it might be useful to have a chat to you guys about this Advanced Health Directives. So hopefully you get something out of it. So what I thought I'd go through is just a bit of a refresher on estate planning in general and the documents involved there, and get into what is the AHD, what's involved in making it, what happens if you don't have one, who makes medical decisions for you if you can't make them, will the directions in the AHD even be complied with, and what if you change your mind down the track about your directions, and then just some practical considerations that you see in practice. So estate planning, so it's obviously more than just a will. A lot of people think that the will just governs everything, but it's important to take a bit of a holistic approach when dealing with estate planning. You've got to find out what forms part of the estate. So the will is only going to govern things that you own in your own name. And so things like superannuation, life insurance, interest in a private company, family trusts, jointly held property if it's held as joint tenants, all those things need to be discussed and considered because they can potentially be dealt with away from the estate, and it doesn't matter what the will says about them because if they don't reach the estate, it doesn't matter what the will says. So it's important to find out all those things and ask all those questions. Also, when I'm taking instructions for a will, it's really important to get the family tree. There was a High Court decision coming out of Tasmania last year or the year before, which is centred around not getting the family tree, and a daughter turned up out of the woodwork and made a family provision application contesting the will, even though the deceased hadn't seen her for 30 years or so. She was successful, and there was a bit of a dispute about the advice given, but it's really important to work out the family tree, see who's eligible, and then give the advisors some strategies to resist any challenge down the track. But as I said, it's not just the will, it's looking at the documents while someone's alive as well, because what happens with their assets while they're alive will channel down to what they're going to have when they pass away. So we've got the enduring power of attorney, the Advanced Health Directive. So it's really important to go through all of this and have all the pieces of the puzzle fitting together. So the AHD, under the Powers of Attorney Act, the state legislation, it's a document that allows the adult to give directions about health matters and also special health matters for future health care. So you can give information about the directions in there, and you can also appoint one or more persons as the attorneys to exercise power for health matters if the directions aren't adequate. And it can also provide terms or information about exercising the power, how it's to be exercised. Quite often I find that people have done the separate power of attorney document already, and they've appointed somebody for financial and personal health matters. So if they've done that, then the AHD has got a section there to say, have you already got a power of attorney for health matters in place? If you have, you just tick yes and then note who that is. But otherwise, if you haven't got one of those, then it gives you the opportunity to actually appoint an for health matters in the document. So the Advanced Health Directive can deal with special health matters, but an attorney appointed under the AHD isn't allowed to consent to special health matters on behalf of somebody. So it's quite a powerful document. The directions in the document, you can consent to future health care, and despite any objection in the future when that care is provided. You can require a life-sustaining measure to be withheld or withdrawn, and you can authorise your attorney to physically restrain, move or manage the adult for the purpose of healthcare, and again, despite any objection by the adult at the time. So they're preparing this document at this point in time when they've got capacity. This is only going to ever kick in when they haven't got capacity, and if they object at that point, well, the feeling is that when they did have capacity back here, this is what they wanted to happen.
Sorry, Trent, can you just confirm what does special health matters mean? I didn't understand that first.
Yeah, special health matters. So it's set out under the Act, and there's a slide. I'll go through some of the examples of special health matters in a moment, but they are, we'll get to it in just a second. Importantly, a direction in the AHD has priority over any general or specific power for health matters that's given to an attorney. And as I said, it's only going to have any effect at all when a person's got impaired capacity. While they've got capacity, they'll just tell the doctor what they want. There's a bit of a push in terms of education, which is great, in promoting these documents, and the Advanced Care Planning Australia website is very good. You've probably been on there and had a look at that. It's got the statement of choices on there, and Joe discussed this at the last seminar we were at, and just having a chat to practitioners as well as people in the industry. The statement of choices isn't legally binding. It's not something that's created under legislation like the AHD or the power of attorney. It's just a separate document that generated to talk about values and create discussion. But it's good in one sense, I suppose, that it promotes that discussion and people can have to talk about it, what their values are around health. Then there's another side of it that says, well, look, we've already got these documents that people haven't fill in anyway, an AHD and an EPOA, and throw another document in the mix that might confuse people. So I don't know, whether there's a right or wrong answer with regards to that. There we go. they're on display here. So you've got the AHD, which is about 30 odd pages, I suppose. And then you've got your statement of choices. There's one that you can do if you've got capacity, and there's another statement of choices for not having capacity. It's a smaller document. Both of them need the doctors to sign off on. So the capacity required to make an Advanced Health Directive document, so presuming that you've already got your power of attorney in place and you're just doing the AHD side of things. So the adult has to understand the nature and likely effects of each direction, and that the direction in there is only going to ever operate while they've got impaired capacity for that particular matter. And that the adult can revoke a direction at any time as long as they've got capacity. And that at any time they're not capable of revoking a direction, or they haven't got capacity, then they can't oversee the implementation of the direction. It's important that they do what they want while they've got capacity. It has to be in writing, and unlike the power of attorney, which has to be in the approved form, the government form, this one may be in the approved form. So there is an approved form that Joe was just showing there. There's some copies on the desk. And most of it, I don't think I've seen an Advanced Health Directive that's not in the approved form using that form. So it's interesting that it doesn't have to be. It has to be signed by the adult or someone else at their direction if they're incapable of signing. And signed and dated by an eligible witness, and then the witness certificate completed. And the certificate has to be signed and dated by the doctor as well, with regards to capacity.
The witness can that be a family member? Because in a lot of legal documents it can't be a family member.
It can't be, no. It specifically states in there it has to be a qualified witness, which is a solicitor, a comdec, a JP or a notary public.
Oh,
And that's a really good point that I didn't realise, that when yourself or a family member or a consumer is filling out the Advanced Health Directive, they then need to get the general practitioner to sign it, but then they need to get a Justice of the Peace to also sign it before it gets uploaded to My Health Record or to the viewer or the health portal with the HHS, or to be held, as a legal document. Because what we're finding is if it's not signed by the JP and the GP, then it's not a legally binding document. So that's a really interesting point I didn't realise until this session. So thanks for that, Trent.
Yeah, no problem at all. Yeah, definitely two parts to it, and we see a lot of them that are completed at home that are done quite a while ago, and they've made the effort and they've gone to see the doctor and done that part, but just forgot to do the next part, which, as Joe said, makes it invalid. And being a witness for those, if some of you are here you go, the eligible witnesses, Justice of the Peace, Commissioner for Declarations, Notary Public or Solicitor, can't be the persons who, if the adult wasn't able to make their signature and said, can you do this sign for me, it can't be that person as the witness, can't be an attorney for the adult, can't be a relation of the adult or even a relation of an attorney for the adult, and the person has to be at least 21 years of age and not a beneficiary under the adult's will. There's a fair few qualifiers, but the check and balance there in terms of who can witness this document. And it's important because the witness, the principal signs it and then the witness signs and dates it, but then on the next page is the witness's certificate, similar to the power of attorney document. And the witness, they're not just signing to say I saw that signature, they're signing to say that they think the person had capacity. And so they can be called upon later to be queried as to what steps they took to satisfy themselves that the person actually did have capacity, what questions were asked and what answers were given. Solicitors have got in big strife for not documenting that process. They may have in their file note just come to a conclusion to say this person signed the document and I felt they had capacity. It doesn't really help somebody, a third party, looking at that in the future, 5-10 years down the track, saying, well, that's nice that you thought they had capacity, but really, what questions did you ask them and what responses were they giving you? And that's a much better process to go through.
just on that, can I ask, so obviously GPs have got experience in understanding what it is to assess capacity, but this extra hurdle in terms of the JP has to also sign it, and if you're saying that signing as a witness brings all of that responsibility as well, are the JPs trained or informed about additional stuff that they're doing, or what?
Yeah, some of the JPs I speak to say they are aware, and the document itself, the witness certificate says, please note that you're not just witnessing a signature here. You should take notes because you might be called upon later. So yeah, they ought to be aware. But yeah, there definitely is a risk.
Yeah, otherwise I don't understand what the point of having to get a JP to sign it is. Do you know what I mean?
Having that second process. Yeah, well obviously the first process is the medical terminology and sitting down and explaining that so they're understanding what they're signing off for, and then understanding the legal effect of it. But what happens if you don't have an AHD? So you've got risks of your health wishes not being carried out at all. Someone might not know what wishes you might want. The substitute decision makers, if you haven't done a power of attorney and there's other substitute decision makers, statutory health attorney or somebody, even the public guardian, they're wondering what you might have wanted in this particular situation. Special health matters, well, they wouldn't have been dealt with because the attorney can't deal with them or consent to those, so there may be costs or delay if there's an application to QCAT, Queensland Civil Administrative Tribunal, requesting that this particular special health matter or special health care be authorised. And also family disputes. So particularly if you've got son and daughter, say, as the attorneys, and they're deciding for mum or dad, what should we do here? If the AHD is in place and there's a written direction, it's much easier for them because mum or dad may have said something around the barbecue to son on this day and then said something different just off the cuff to mum, and that's all they've got to go off. And so it can cause a bit of cause a bit of dispute. So this helps get rid of that. So who makes the decisions for you? So you've got your substitute decision makers when you don't have capacity. There's a range of them. You can have an attorney for personal health matters that you've appointed while you did have capacity under an enduring power of attorney document, or under the AHD where it gives you that ability to nominate an attorney. If you haven't taken that step, then somebody has to make health decisions for you. And so the government, under the Powers of Attorney Act, has just listed an order of priority called the Statutory Health Attorney, and they'll make the decision about health. There's also a potential for a guardian to be appointed through QCAT. The tribunal can make a decision, and so can the court. So the Statutory Health Attorney, they can make any decision about a health matter that the adult could lawfully make if they had capacity, but not special health matters. And they can obviously only exercise that power when the adult has lost capacity. Who is the Statutory Health Attorney? So it's the readily available and culturally appropriate of the following. So first up is the spouse. If the relationship is close and continuing, they'll make the call. Then if there's no spouse, or the relationship's not close and continuing, a person 18 years or more who has the care of the adult but who's not a paid carer for the adult. There's no one in that category. A person 18 years or more who's a close friend or relation of the adult and is not a paid carer of the adult. And if there's no one in that category, then public guardian has the sort of default position. Who'll make the decision.
Can I add to that? This is something else that Trent taught me last month, was that we often get the question, if you're on a carer's allowance, are you allowed to sign? And yes, you are, so long as you're not a private paid carer.
Yeah,
Does
that's
that make
right.
sense?
That's right, yeah.
Okay.
The husband and wives always come in and say, oh, I better not sign that, I'm getting the carer's pension from Centrelink, but that's okay.
So that's
It's also interesting that you're saying who the statutory health attorney is over 18 years, and yet for the signing they have to be over 21.
For a witness, yeah, exactly right.
interesting.
I'm not sure why. You're responsible enough at 18 to make these decisions, but you're not responsible enough to
The signing,
be a witness. I just noted there's a bill before Parliament at the moment called the Guardianship Administration and Other Legislation Amendment Bill, a mouthful. It's tweaking Powers of Attorney Act, Public Guardian Act, Guardianship Administration Act, and just with regards to this side of thing, who the statutory health attorney is. The part's in italics, so for a spouse, they want to put the wording at the front of that, a person who is 18 years or more and is a spouse. For the person who has the care of the adult and is not a paid carer, they also want to add in who's not a health provider for the adult and who's not a service provider for a residential service where the adult is a resident. So there's some protective mechanisms there. And with regards to relation, they're going to put a definition of relation in there to say the person is a relation if they've got a close personal relationship with the adult and a personal interest in the adult's welfare, who is related by blood, spousal relationship, adoption or foster relationship. And there's mechanisms there for Aboriginal and Torres Strait Islanders with regards to what a definition of relation might be there, taking into account tradition and customs. So those changes haven't been not into force yet. Guardians. So we have the statutory health attorney, one possible substitute decision maker. The next one, or another one, is guardians that are specifically appointed by QCAT. So QCAT is allowed to appoint a guardian for a personal matter if they're satisfied, A, that the person has impaired capacity, B, that there's a need for a decision in relation to the matter, or the adult's likely to do something that involves an unreasonable risk to their health or welfare or property, and that without an appointment the adult's needs won't be adequately met, or their interests won't be adequately protected. In my experience, it's in a few of the applications that we've done for people where they wanted to be appointed the administrator and the guardian, so administrator for the financial side of things, the guardian for the health side of things. It's come back and the QCAT has said yes, it's appropriate that you be the administrator to look after the financial things, but they dismiss the guardianship side of things. And as I was saying last time, I think the reason for that is that when you're appointed as a guardian for someone, you're taking away some very core rights of a person. So I think it's more a lot to do with preservation of someone's human rights about these very intimate personal decisions. And where they can, they're saying, well, the person might be able to decide, I don't know, where they live or what they're going to wear that day. Those kind of decisions, which are important for keeping independence. They'll make the decision if it's necessary and if it ticks those boxes, but it's just something that I see. The less common would be where a decision is made by the tribunal itself, or special health care, for example, or the court, even less likely. So your query about special health care, special health matters. So it's defined in the Act as these things: removal of tissue where a person's alive for donation to someone else, sterilisation, termination of a pregnancy, participation in special medical research or experimental healthcare, ECT or non-ablative neurosurgical procedures, and some prescribed special healthcare. So I guess they're the very serious kind of decisions. They don't want an attorney just to have that power to make it. They want to. The tribunal wants to keep that supervisory power over these very important decisions. Okay, so under the Guardianship and Administration Act, healthcare can be provided with or without consent in certain circumstances. So healthcare with consent under Section 65, special healthcare. If it's been addressed under the AHD, then it can be done. That's treated as consent. But otherwise, if it's not under the AHD, it can only be with the consent of the tribunal or the court. So as I said, the attorney doesn't have the power. Healthcare is defined as care or treatment or a service or a procedure for the adult that's used to diagnose, maintain or treat the adult's physical or mental condition, and is carried out by or under the direction or supervision of a health provider. And it includes withdrawal or withholding life-sustaining treatment. And that's important too, the wording there. If the commencement of that treatment or continuing with it would be inconsistent with good medical practice, on a ventilator or something like that, or CPR. There's lots of definitions, and it's sort of snakes and ladders in terms of things when you're looking through the legislation, because it talks about, well, it's only if it's inconsistent with good medical practice, then you have to work out, well, what is good medical practice? This is defined as good medical practice for the medical profession, having regard to recognised standards and also ethical standards. Object is also defined in the legislation because, in general terms, the care can't be provided if it's known that somebody objects to that care being provided. So object means the adult indicates they don't wish to have the care, or the adult previously indicated in similar circumstances that they didn't want it, and since then they haven't indicated otherwise. So they can do that through an EPOA or an AHD or even orally.
So if I can add, so this comes up quite a lot in emergency departments, as you can imagine, when the person may not have capacity and the carer or the family member says they would want this, but there's no Advanced Health Directive. Then unfortunately the medical officer, and John, jump in please, then the medical officer has to do what is considered good medical practice in that situation.
Yeah, so you, as a doctor, you always have to be acting in the best interest of the patient unless you have a directive sort of contrary to that. So where it's written down, it's nice and easy, but then if obviously there are circumstances where you will have that second order directive where you have relatives who know the person well and have a good understanding of what their wishes would have been, which then can impact, whether someone would have a normal sequence of care or not.
Yeah, and it'd be reassuring if those wishes are consistent with what you perceive to be good medical practice, so it gets carried out. The healthcare with consent, so there's an order of priority. So the top one shows you how powerful the AHD is. If the adult's made an AHD giving a direction about a particular matter, then it can only be dealt with under that direction. But if there's no AHD and QCAT's put a guardian in place and the guardian makes the call, if there's no AHD or guardian or order and they've got a power of attorney, then the attorney makes the call. If there's none of that, then the statutory health attorney will step up. So a bit of an order of priority there. Healthcare without consent, so the urgent healthcare, may be carried out without consent if the health provider reasonably considers that the adult's got impaired capacity for the matter and either one of these things. The healthcare should be carried out urgently to meet imminent risk to the adult's life or health. It's one of them, but under that one, it can't be carried out without consent if the health provider knows that the person objects to it in their Advanced Health Directive. Or the other time is that the health care should be carried out urgently to prevent significant pain or distress to the adult, and it's not reasonably practical to get consent from a person who can give it under the Act or the Powers of Attorney Act, so the substitute decision maker. And then under that one, if you're relying on that second one, the health care under that one can't be carried out without consent if the health provider again knows that the adult objects to it. But then there's another qualifier. Even if they know the adult objects to it, they can if the adult has no or minimal understanding of what the healthcare involves and or why the healthcare is required, and the healthcare is likely to cause the adult no distress or temporary distress that is outweighed by the benefit to the adult of the healthcare. So, I don't envy you trying to work out all of that in a quick situation. There's a separate section dealing with withdrawal or withholding life-sustaining measures without consent. That's been dealt with here. So life-sustaining measures, healthcare intended to sustain a prolonged life that supplants the operation of vital bodily functions. So things like CPR, assisted ventilation, artificial nutrition and hydration. Doesn't include a blood transfusion in this particular definition. So for healthcare without consent, if it's a life-sustaining measure, CPR for example, it may be withheld or withdrawn without consent if the health provider considers reasonably that the adult's got impaired capacity and commencing it or continuing with it would be inconsistent with good medical practice. And consistent with good medical practice, that decision has to be taken immediately. But again, the measure can't be withheld or withdrawn if the health provider knows the adult objects to it. You've got the AHD there, if the health provider is aware of the AHD. Consent to withholding or withdrawing life-sustaining measures. So if consent is by the guardian or the attorney or the statutory health attorney to turning off the machine, for example, they do have that power. An attorney under a power of attorney can make that call. But it can't operate unless the health provider considers that the commencement or continuation would be inconsistent with good medical practice. So if you've got an attorney saying, yeah, let's switch it off, the health provider's still got some say in the matter, quite a lot of say, depending on whether it's going to be inconsistent with good medical practice or not. If consent is not through the attorney or a statutory health attorney, but it's actually relying on the Advanced Health Directive document, well, that can't operate unless one of these following applies. It's 4 conditions. So the adult has to have a terminal illness that's incurable or irreversible, and in the opinion of the doctor, they might be expected to die within 1 year. Again, that's a tough call to make. The principal is in a persistent vegetative state, a condition involving severe irreversible brain damage, which allows the vital bodily functions to continue, such as a heartbeat or breathing. The principal is permanently unconscious, for example, a coma, the principal has an illness or injury where there's no reasonable prospect that they'll recover, and they can't continue on without this life-sustaining measure. And if we're talking about pulling out drips, artificial hydration, if the commencement would be inconsistent with good medical practice. And also you have to have this qualifier that the principal's got no reasonable prospect of regaining capacity for that matter. So in general terms, if the health provider knows or ought to reasonably know that there's an objection, then the care shouldn't be exercised. However, even if there is an objection, if the adult's got a minimal or no understanding of what the healthcare involves or why it's required, and if the healthcare is likely to cause the adult no distress or just temporary distress that's outweighed by the benefit, then it's okay. As I said at the start, in the AHD, the adult consents to particular future healthcare despite objection by the adult when the healthcare is actually being provided. So I think the government or the legislation, when it was made, recognised the difficulties that a health provider might be facing in terms of making these decisions, and there's relief available from liability. So under Section 102 of the Powers of Attorney Act, if the person didn't know the adult has an Advanced Health Directive, then that's okay. In the new legislation, they add into that Section 102 and the health provider's acting in good faith. I don't know what that sort of addition may mean. Does that put some kind of positive onus on a doctor to ask about Advanced Health Directives? I don't know. Section 103 of the Power of Attorney Act says a health provider has reasonable grounds to believe that direction in an Advanced Health Directive is uncertain or inconsistent with good medical practice, or that circumstances such as advances in medical science have changed so that the direction is now inappropriate. The health provider won't incur any liability to the adult or anyone else if they don't act in accordance with that direction. And if an attorney is appointed under the AHD and the health provider has reasonable grounds to believe that a direction in that is uncertain, they can only say it's uncertain if they have consulted with the attorney to say, what do you reckon they meant by this? And if they still can't work it out, then can rely on that one. To the extent that a health provider gives healthcare to an adult in compliance with a purported exercise power for a health matter by someone who represents that they've got the right to exercise it, then the health provider's taken to have the consent. So this is potentially where the relative says, yeah, I'm the attorney or the statutory attorney, I think this should happen, and it gets done for whatever reason, and we find out later that they weren't the statutory health attorney. The health provider's not going to be liable there, provided that the health provider didn't know or could be reasonably expected to know that the person shouldn't be the one exercising the power. So again, I don't know what the threshold is about the level of inquiry that needs to be made of these people. It's difficult. Alright, so what about if someone wants to change their mind? They've done the AHD and then they want to change their mind. They can revoke the direction, but only if they've got capacity.
Can I just interrupt? I hear capacity all the time and it makes me shudder because is there anything in place that legally guides somebody to know what capacity actually is and how it's determined?
Yeah, really good question. The bill that's put before Parliament now has got a requirement for guidelines to be developed regarding that. Capacity, there's no single test for capacity. You can't have blanket capacity for everything. It's task specific. So for a will, for example, there's a case from the 1800s called Banks v Goodfellow that says if you want to have capacity for a will, you need to understand the nature and effect of your assets, who's in your family, who should have a claim on your bounty. You've got no insane delusions affecting your decision as to where things are going. So that's the test for the will. But then for a power of attorney, completely different test. Power to enter into a marriage, a contract, all these different tests. And it's just task specific. And then the tricky thing is that within the task, the level of the decision is also then factored in. So if you're looking at somebody having capacity to make a decision about their finances, or maybe they can't go and buy cryptocurrency, but they can have a few bucks in their pocket to go buy the paper. So yeah, it's a really grey, tricky area, and they are looking to develop some guidelines to help.
I'll just say in a medical perspective, I mean, with this sort of 3 tenors of capacity, be able to understand the thing, be able to make a decision based on that information and then communicate that information. So often in the medical thing, it's about the communication part. Are they able to fully communicate it because they had a stroke or things like that? And so that often is the main issue. And then the other 2 ones, obviously, like you said, they can be very tricky because it can be very, depending on what decision they're making, it requires different cognitive.
And if the person making that decision about their capacity is not a medically trained person, there was earlier on in the piece, was there some there was some note there
about the witnessing.
You determined that, and those witnesses then had to know what capacity was, and they may not be medically trained or medically able to determine that.
Exactly right, and even a solicitor, they're not medically trained. It's really about the process, so you can't stress enough about you've got the test for capacity written in there. It says the person must understand these things in your statement of understanding, so you've got that there. And then what I'd recommend if you're a JP or a contact, even a solicitor, whoever, you've got your test there, and then you ask your questions, your open-ended questions about that to test them. And then you just write down what the responses are. If you're in significant doubt, then you probably wouldn't go ahead with it. The court cases around capacity and when it's dealing with solicitors anyway, about whether you take the instructions, whether you sign the document, there's a suggestion there that if in doubt and it's borderline, then just do it, because you're not there to decide capacity. That's for a later court to determine if the person had capacity down the track. All you can do is help by jotting down your process as to how you satisfied yourself that they were okay to sign this document. The review provisions at the back of the AHD, so at the last page, there's a little spot there where you can say, yeah, I've had a look at this again, might be a 2003 document, I've checked through it all, there's nothing that I'd like to change, and you can sign it and date it. And so that assists there with one of the reasons that the health provider might not comply with it is that there's been advances in medical science that might make that direction null and void now from 2003. But if you've gone through it and you've updated it and now it says 2018, well, that might resist the use of that particular method to not comply. So practical considerations, as I said, it's a very useful document. Traditionally, or quite a while ago in my practice, it was just sort of like an add-on. You do the will, you've got a power of attorney, that would be even less common, and then you say, oh, what about the AHD? And people go, nah, don't worry about it. But now I'm sort of pushing it a bit more actively, because I see the benefits of it. It provides a lot of clarity for people as to the decision making about their health, what they want, and importantly, looking at it from the people who are left making the decision, it takes away some of that guilt. I use an example where you might have 2 decision makers and they're appointed severally. So son and daughter again, they're appointed severally, which means either one of them can make the decision on their own. Daughter might be away overseas somewhere, uncontactable, something happens to mum, decision has to be made, son's in there, he's got to make this call. Now, he makes the call, but he's left with the ramifications of that call, whatever they may be, good or bad. And I think having this document in place may assist in those situations to just help alleviate some of that guilt for the people who you love going forward.
Are you also suggesting too that this should be like your will and that and revisited every few years? Because I just picked up there that if you've made out one of these 10 years ago when, say, cancer was at this stage and you've got to this level and there's no coming back, but 20 years down the track, when you do go through that,
Yes.
and there is now a cure, then that's no longer relevant?
Yeah, most definitely.
Okay.
It can be used, that's one of the outs, I suppose, that a health provider has if the science has changed. So, yeah, definitely all these documents for your estate plan, they're not like a set and forget thing. You've got to update them and just make sure, even for a will, it might be just pulling it out of the drawer, wherever it is, making sure it still reflects your wishes and chucking it back in. Just taking that step is very important. Usual lawyer disclaimer. That's all I wanted to have a chat to you about. Any questions?